Before a dog's owner can be held liable, does the dog get one free bite? That was the question in the case of Blackie the farm dog. In this case, Shane Ross, a minor child, was attacked and injured by Blackie, a shepherd farm dog owned by Hanson. Hanson and Ross families both ranched in the same area, and both families were on friendly terms. Shane and his brother went with their dad to the Hanson place to pay for a horse. While there, Hanson wanted to drive to a pasture to look at other horses, and they all got in Hanson's pickup. The two boys rode in the back with Blackie and another farm dog. There was no trouble with the dogs on the way out to the pasture. However, Hanson testified when they traveled about a mile back towards the home place, he heard a dog growling. He stopped the truck, found Blackie astraddle Shane Ross, and the dog had bitten the boy. As a result of the dog bite, Shane sustained a serious injury to his right eye. The jury found for the plaintiff and awarded money damages. The dog owner appealed and argued that the dog seemed fine, and there was insufficient evidence to show that he knew or should have known of Blackie's dangerous propensity prior to its attack on the child. How would you decide this case? Is the owner of the dog liable? We'll be back in a moment to answer that question. Was there sufficient evidence to hold Blackie's owner responsible for the injury caused by his dog's bite? Yes, said the South Dakota Supreme Court. There is no rule that every dog gets one free bite in South Dakota. The court said, proof of negligence on the part of the owner in keeping or restraining a domestic animal is not essential to liability. The gist of the action is the keeping of an animal after knowledge of its vicious propensity. During the trial, there was evidence that Blackie had previously bitten the owner's niece, but there was no record of any injury being done to that child. The owner admitted that he knew Blackie had bitten before, and that he should have got rid of the dog, but never got around to it. This extrajudicial statement was admissible as an exception to the hearsay rule, as a statement against interest, tending to prove the material fact of the owner's prior knowledge of the dog's vicious propensity. On appeal, the court found sufficient evidence in the record to support the jury's award of compensation. Remember, it's a matter of law.